What's missing from the Fourth Amendment is a way to make sure the police obey it. Not only that, most crime is handled by local police and state courts, and several states never enforce the use of warrants, so police just stop getting them. If they searched a house without one, that evidence would be used in a trial anyway, so...
Police officers, knowing that a warrant was not necessary, would conduct warrantless searches because they knew that there were no ramifications for their actions. And so there was nothing to deter them from acting in an illegal fashion.
So when Sergeant DeLisle rang Dolly Mapp's doorbell, he didn't have a warrant, and she didn't invite him in. She believed she had rights to protect her.
I haven't committed a crime, so why are you here? I called the lawyer.
She was a legally sophisticated person. She went back, she talked to an attorney, and the lawyer said, don't let them in if they don't have a warrant.
So the police went away. 3 hours later, they come back again.
They broke a window and then they pried open the door in order to gain entry to the house.
And when I looked up, they were in my house.
So it's important to recognize that Dolly had not let them in the home. In fact, she continued to tell them they were not welcome, but they entered the home anyway.
And they say, we have a search warrant. And Dolly Mapp says,
may I see the warrant?
So the police officer there pulls out a piece of paper and waves it in front of her and starts putting it back.
She grabbed the piece of paper and put it down her blouse.
Turned out that paper was not a warrant. The police never got one. At this point, though, they handcuffed Dolly Mapp and searched her house. They actually found their suspect downstairs, so he was there, but he was also released the next day because it turns out he had nothing to do with the bombing. They didn't find anything else related to the bomb, but in an upstairs dresser, the police found some pornography that Dolly Mapp says was owned by one of her former boarders.
They found some materials that led to her being prosecuted for obscenity, possession of obscene materials. One of the things they found up on the second floor were erotic comic books.
Okay, take a moment. It's okay to giggle. Even Dolly and one of the officers laughed that day.
I didn't think I was in any trouble. The officer enjoyed looking at him himself.
But the laughter ended quickly. Although they didn't charge her with anything having to do with the bombing, Dolly was charged with possession of obscene materials. For having this in her home, even though it wasn't hers, she was facing 1 to 7 years in prison and a fine of up to $2,000.
It's astonishing. It's a terrible law. The Ohio law prohibited possession of obscene material, so it was quite a broad anti-obscenity law.
At her trial here in the Cuyahoga courthouse, Dolly and her attorney, A.L. Kearns, tried to have the evidence thrown out or excluded. They claimed the search was unconstitutional since there was no warrant. That's called the exclusionary rule.
The exclusionary rule is a rule that says if the police obtain evidence in violation of your Fourth Amendment rights through an unreasonable search or seizure, that evidence can't be introduced against you in a prosecution.
The exclusionary rule in the American legal system goes back to 1914 in a case called Weeks v. United States, where the court said that if a federal law enforcement officer found evidence illegally, that evidence could not be used against the defendant.
This was tremendously important because it was the first time that the Supreme Court recognized that the Fourth Amendment sets out certain rules, and that if the police don't follow those rules and they obtain evidence, that evidence should not be used.
Okay, so a minute ago I pointed out that missing from the Fourth Amendment was any way to enforce it. The Weeks decision was the Supreme Court's way of trying to fix that. It said to police, if you don't have a warrant, you can't use the evidence. The exclusionary rule was the court's way of enforcing the Fourth Amendment. But at the time of Weeks, the Fourth Amendment did not apply to the states. It's a little confusing, but here, check this out. The Bill of Rights gives us all these wonderful rights and freedoms, but it only applied to the federal government. See, Congress shall make no law. Then in the early 20th century, the court started to apply some of these fundamental rights to the states through the 14th Amendment, written and ratified after the Civil War to rein in the states. This process is called incorporation, but the court was split about how far to go.
And what happened eventually was the court said, we're not going to say, take the Bill of Rights as a whole, it applies against the states. We're going to consider each right individually, and we're going to ask, is it sufficiently important that we think the states have to observe it?
So 35 years after Weeks, the Supreme Court handed down a ruling on the Fourth Amendment in Wolf v. Colorado. The Wolf decision said that states have to incorporate the rights in the Fourth Amendment, but states don't have to use the exclusionary rule to enforce those rights, because the exclusionary rule isn't in the Constitution.
In the Wolf decision, the Supreme Court had said, you've got this right, a right to be free of unreasonable searches and seizures, but that right is quite distinct from the exclusionary rule.
The Supreme Court says, oh, the Fourth Amendment applies against the states, but not the exclusionary rule, because the exclusionary rule isn't really a key part of the Fourth Amendment. That's just something that we judges have come up with as a device for enforcing the Fourth Amendment.
Justice Felix Frankfurter wrote the 6-3 majority opinion in Wolf, calling the exclusionary rule a judicial-made remedy that is not actually in the Constitution, so the states didn't have to use it.
If the Constitution itself doesn't give you that remedy, then you're not necessarily going to have it in state courts.
So here's what all of this means for our case and for Dolly Mapp. Ohio didn't recognize the exclusionary rule. Instead, the state allowed evidence found illegally to be used in court. So the pornography the police discovered at Dolly's house was introduced into her trial, and a jury found Dolly guilty of breaking Ohio's obscenity law.
She was sentenced to the maximum, which was 7 years, plus a $2,000 fine.
7 years for what? That case wasn't right. It was illegal to do this to me.
Dolly's lawyer appealed, but mainly on the issue that Ohio's obscenity law violated the First Amendment protecting freedom of speech, and her case went all the way to the United States Supreme Court.